We're reading Barbri Commercial Outline. We're reading first year contracts and sales on page 101. We're in section 8. But we're talking about monetary remedy damages right now. The most frequently sought remedy for breach of contract is an action at law for damages. In cases of willful breach, courts are more likely to be flexible in determining the plaintiff's damage alternatives. So, types of damages. You have A, compensatory damages. B, punitive damages. C, nominal damages. D, liquidated damages. Before we start going into the sale of goods. So, compensatory damages. A, the purpose of contract damages is to give compensation for the breach. For example, to put the non-breaching party in the position she would have been in had the promise been performed. So far as money can do this. The most common measure of this is the value of the breaching party's performance that was lost, which is in parentheses titled expectation damages. Plus incidental and consequential damages, less any loss or cost saved by not having to perform. So compensatory damages, standard measure, no, okay. Compensatory damages include expectation damages and reliance damages and consequential damages and incidental damages for contracts for the sale of goods, and then we talk about the certainty rule. So the standard measure of damages is the expectation damages. In most cases, the plaintiff's standard measure of damages will be based on the expectation measure, which is, for example, sufficient damages for her to buy a substitute performance. This is known as benefit of the bargain damages. Reliance damage measure. In the plaintiff's expectation damage, if the plaintiff's expectation damages will be too speculative to measure, for example, the plaintiff cannot show with sufficient certainty the profits she would have made if the defendant had performed the contract, the plaintiff may elect to recover damages based on a reliance measure rather than an expectation measure. Reliance damages award the plaintiff the cost of her performance. For example, they are designed to put the plaintiff in the position she would have been had the contract never been formed. For example, J-Mart gives Sam a dealer franchise to sell J-Mart's products in a stated area for 1 year. In preparation for performance, Sam spends money on advertising, hiring sales personnel, and acquiring premises that cannot be used for other purposes. J-Mart then repudiates before performance begins. If it cannot be established with reasonable certainty that what profit Sam would have made if the contract had been performed, for example, Sam's expectation damages, Sam can recover as reliance damages his expenditures in preparation for the performance. And third, under compensatory damages, we have consequential damages. Consequential damages are special damages that reflect losses over and above standard expectation damages. Usually, these damages result from the non-breaching party's particular circumstances. Usually, consequential damages are lost profits resulting from the breach. These damages may be recovered only if I, at the time the contract was made, a reasonable person would have foreseen the damages as a probable result of a breach. In Roman numeral 2, the damage would not have been avoided through reasonable efforts. In Roman numeral 3, the damages can be proved with reasonable certainty. Whether damages were avoidable and whether they are certain are issues with respect to any recovery. Foreseeability is a key issue for consequential damages. To recover consequential damages, the plaintiff must show that the breaching party knew or had reason to know of the special circumstances giving rise to the damages. For example, Alex and Becky make a written contract under which Alex is to recondition by a stated date a used machine owned by Becky so that it will be suitable for sale by Becky to Cindy. Alex knows when they will make the contract that Becky has contracted to sell the machine to Cindy, but knows nothing of the terms of Becky's contract with Cindy. Because Alex delays in returning the machines to Becky, Becky is unable to sell it to Cindy and loses the profit that she would have made on the sale. Becky's loss of reasonable profit was foreseeable by Alex as a probable result of the breach at the time the contract was made. Now, this is discussed under the Restatement of Contracts, Restatement Second of Contracts, Section 351. Compare paragraph. Suppose in the above example that the profit that Becky would have made was extraordinarily large because Cindy promised to pay an exceptionally high price as a result of a special need for the machine. Again, Alex is aware of the contract with Cindy but unaware of its terms. Alex is not liable for Becky's loss of profit beyond what would ordinarily result from such a contract. The exceptionally high price paid by Cindy was not foreseeable by Alex as a probable result of the breach at the time the contract was made. Note that in contracts for the sale of goods, only a buyer may recover consequential damages. Now 4, incidental damages, which is under compensatory damages. Contracts for the sale of goods. In contracts for the sale of goods, compensatory damages may also include incidental damages. Incidental damages include expenses reasonably incurred by the buyer in inspection, receipt, transportation, care, and custody of goods rightfully rejected, and other expenses reasonably incident to the seller's breach, and by the seller in storing, shipping, returning, and reselling the goods as a result of the buyer's breach. Last, we talk about the certainty rule. The plaintiff must prove that the losses suffered were certain in their nature and not speculative. Traditionally, if the breaching party prevented the non-breaching party from setting up a new business, courts would not award lost profits from the prospective business as damages because they were too speculative. However, modern courts may allow lost profits as damages if they can be made more certain by observing similar businesses in the area or other businesses previously owned by the same party. Now that we leave compensatory damages, we have punitive damages. Punitive damages awarded to punish the defendant for wrongful conduct are generally not awarded in contract cases because these are something that are germane to tort law. Nominal damages. Nominal token damages, as they're referred here. Example, $1 may be awarded where a breach is shown but no actual loss is proven. And liquidated damages. The parties to a contract may stipulate what damages are to be paid in the event of a breach. These liquidated damages must be in an amount that is reasonable in view of the actual and anticipated harm caused by the breach. Within liquidated damages, we have some requirements for enforcement. Liquidated damage clauses will be enforceable if the following 2 requirements are met. You have Roman numeral 1, damages for contractual breach must have been difficult to estimate or ascertain at the time the contract was formed. And Roman numeral 2, the amount agreed on must have been a reasonable forecast of compensatory damages in the case of a breach. The test of reasonableness is a comparison between the amount of the damages prospectively probable at the time of the contract formation and the liquidated damages figure. If the liquidated damages amount is unreasonable, the courts will construe this as a penalty and will not enforce this provision. And UCC Rule allows a court to consider actual damages to validate a liquidated damages clause, even if the clause was not a reasonable forecast of damages at the time of the contract formation. It will be valid if it was reasonable in light of the subsequent actual damages. This is discussed in the UCC now, 2-718. Now, 2 and 3 under liquidated damages is recoverable even if no actual damages, and effective electing liquidated or actual damages. So, 2. If the above requirements are met, the plaintiff will receive the liquidated damages amount. Most courts hold this is so even if no actual money or pecuniary damages have been suffered. Should one or both of the above requirements not be met, the provision fails and the plaintiff will recover only those damages that she can prove. Now, 3, effect of electing liquidated or actual damages. Should a contract stipulate that the plaintiff may elect to recover liquidated damages set by a clause or actual damages, the liquidated damages clause may be unenforceable. So we're on page 104 now, about to discuss contracts for sale of goods, because buyer damages are separate and distinct, as well as seller damages from those damages that we've discussed earlier, which I want to say are common law versus the UCC, which is usually applicable to the sale of goods. We're going to go with that and continue another time.